You recall that prior to today's proceedings, the court had made a very clear order that proceedings shall be from day to day in accordance with the provisions of the Administration of Criminal Justice Act. And that is what we have always stressed before this court, that there is a subsisting order that should be complied with. And that was why we informed the court that the defendant has sought adjournment before this court for 10 times, which is contrary to the provisions of the ACJA, which says that it shouldn't be more than 5 times. So that has been our argument before the court, that there shouldn't be any further delay. We say no to any dilatory tactics by the defendants, and that has been our take from the beginning of these proceedings.
Okay, so what has the court ruled in terms of the subpoena?
Oh yeah, actually the defendant's counsel stated that they filed a subpoena, but the subpoena by law has to be issued, signed by the judge. But unfortunately, it hasn't been signed, and that was the basis upon which they requested for an adjournment. But we told the court, we made an application that they have not shown any seriousness, because this is the 10th adjournment. So we impressed it on the judge to foreclose them, because we cannot allow any further dilatory tactics in this matter. And that was the basis why we asked that the court foreclose them. And that's what we simply did.
So for the record, your name and...
My name is Yemi Kuiton, Senior Advocate of Nigeria.
Thank you.
Thank you. Thank you. Thank you.